My Lord, may I beg to mention, my Lord, item number, my Lord, 6. I'm for petitioner. And, my Lord, item number 4 to 14 and 17 to 19.
Just
Four,
one.
my Lord.
Item number 6.
Item number 6. My Lord, may some time may come up next week. In fact, I have some personal difficulties where Lordship has directed for inquiry in Nongpo airport matter. It is fixed today because of
2 weeks then.
2 weeks, my Lord.
On pre-made by the petitioner, this is matter after 2 weeks.
My Lord. And item number, my Lord, part of matter, item number 8 to 14, 17 and 19, 17 to 19. This is part of matter. In fact, Lordship has heard us in the last occasion.
Item number?
Item number 8 to 14 and 17 to 19. These are all listed together.
Okay,
So,
okay. Those are school matter?
Yes, Lord.
School teachers matter?
My teacher's matter, Lordship has heard us. It's a part of matter.
This matter was also before the Lokayukta?
Early,
Lordship,
one
yes.
petition. One person was filed the logo with the petition. Pick up after 10 days, if Lordship please.
Let it be 2 weeks, Your Lordship. 2 weeks.
On pre-made by the petitioner, this is matter after 2 weeks.
2 weeks. Oblige, Your Lordship.
Obliged.
Yes, Your Lordship. Your Lordship, I beg to mention item number 15. Your Lordship, if the matter may be fixed on the 5th, sure.
You are for?
Respondent number 1.
Who is for petitioner?
I'm for the petitioner. No objection, my lord. My lord, today we also have difficulty, my lord. Mr. Paul is not here today.
On pre-made by the parties, this is matter after 2 weeks.
My lord, I beg to mention item number 3 and 4, my lord. Mr. Paul has some personal difficulties today, my lord. So I'm praying if this matter can be listed after a week, my lord. My lord, this is very old matter, I understand.
Like I said, you see, these are old matter.
My lord.
You should try and dispose it. Because finally, you see, even you have to understand the plight of the court. What happens is, more often than not, when these old matters are disposed of, I find at the end of the day, you see, the cause of justice is not served. Either the petitioner or the respondent would have lost out. So eventually, if not, in actually, but it will become in functions. The whole issue becomes. This is with regard to your subsidy.
Subsidy, my lord. Item number 3 is regarding the subsidy.
Any element of interest involved.
My lord.
So that has to be on pre-made by the petitioner. List this matter after 2 weeks. 3, 4.
Yes, my lord.
Please, Your Lordship. Item 20, my lord. I'm for the petitioner. Mr. Sheikh is for the opposite side, my lord. He requested me that he'll be going for Eid. I'm praying for an adjournment.
On pre-made by the parties, list this matter after 3 weeks.
Obliged, Lordship.
Supplementary cause list item number 1. May it please Your Lordship. Your Lordship, the conducting counsel is on legs before Justice Thank You School. Your Lordship, we pray that this matter may be listed at the end of the board.
End of the board.
Item number 2.
Your Lordship, similar prayer for item number 2.
Item number 3.
Lordship, we are filing a synopsis. I've given it.
You are for?
For the petitioner, Your Lordship.
And for the respondent, Your Lordship, we'll be filing the synopsis.
Parties have filed their respective written synopsis. Accordingly, matters now reserved for judgment.
Much obliged, Your Lordship.
Daily costless item number 1.
May it please the Lordship, if this matter may come up at the end of the vote, my Lord. As the learned DSGI is on legs before Justice, thank you, Court, my Lord.
Okay.
Much obliged.
Item number 2.
Lordship, this is the St. John's matter, my lord.
Yes, what is,
As per
have
the-
you,
Yes, we had
you said,
met yesterday, my lord. The concerned person's authorized signatory had gone to the office yesterday, and I'm instructed, my lord, that some discussion was done, but I have to complete, my lord. It appears that it has not been fully resolved yet, but some discussion has been done, my lord. But my only prayer today was, my lord, the bank account still remains to be frozen, my lord. That is creating, because what is happening, my lord, is that they have frozen the bank account from the month of April onwards. Now for the month of April, my lord, the EPF for the month of April, the monthly contribution, is deducted from the same account. That, because of the freezing of the account since April, the contribution for April, which was to be made in May, and also the contribution of May, which was made to be made within 15th of June, has also, my lord, been stalled. So we are also apprehending that those also will be, my lord, now, because these are computer generated, so those also will be added to the claim. Over that, the damages and the interest. So this will keep on going. So, my lord, my only prayer was that we are trying to resolve it, my lord, with regards to that period. But currently, the account should not be, my lord, kept frozen, because they are also not able to recover. We are also not able to use the account, and the school, my lord, is, because all the payments of the
but who's appearing?
council was there, my lord, Miss Bhattacharjee.
But if she's not here, what to do?
She's not on leave also, my lord.
We'll do one thing, we'll take it up at the end of the board.
Lordship, I'll
You try to contact them.
oblige, lordship.
Item number 5.
Yes.
We have concluded our submission on the last occasion, my
You have concluded?
lord. Whatever learned senior argued, reply to that, my lord. This is regarding that, my lord, that dismissal from
Yes.
the jailbreak matter, my lord.
Jailbreak. So you tell me again, since the jailbreak, you have been suspended.
My lord. I was suspended, then I has been removed from the service.
Okay, but the proceedings, disciplinary proceeding has been completed.
My lord. It's been
So
completed.
against the finding of the disciplinary authority, you have approached this court.
My lord.
Okay. Yes, Mr. Khan.
May it please, Your Lordship. So we just come to page 90, annexure 16 of the writ petition.
So,
Page 16, Your Lordship. Page 90, annexure 16, 25 to 2014.
page 19
90.
or 90.
Sorry.
Yes.
Lordship, this is the final order, and the appellate authority's order, which had confirmed the entire proceeding previously. So basically, they agree. Basically, the first round of agreement is this: this order is not a speaking order. They should have considered their prayer, which they made earlier, but which was not considered. So first, Lordship, we have to overcome the hurdle whether this order is a speaking order or it is taken into account. So Lordship, allow me to just go through it because we had did the hearing a long time back. So this will escape you, Lordship. So just go through it. As seen from the order of the Honorable High Court 338 of 2013 in case of so and so, had filed an appeal under Section 13 of the Assam Appeals Rules against an order of DP 12/4/2012. So Lordship, Section 13 appeal, first thing is this has been filed pursuant to the order of the Honorable High Court. Because before that, Your Lordship, I will not go into that. Before that, there was some issue that they had to come to the court and appeal was not filed, so they got a court direction. So technically, this was the only issue that they had raised in the earlier writ petition. But that situation is changed after High Court gave a direction. So now this appeal was filed challenging the DP of 12/4/2022 passed by Director General of Police, imposing the order of removal from service. So we have a very limited scope. Against the removal of service, appeal was not preferred. Appeal has now been preferred based on High Court order. So whether this appeal that has been preferred, whether it take into consideration, it takes all the relevant facts into consideration. It has gone to that or not. That is the main subject, Your Lordship.
You see, what the court would seek to understand is whether the due process has been followed.
Absolutely correct.
If there's an aberration,
absolutely, Lordship. Then court will strike the clock back and say start back from that part. So the import of this particular order, Lordship, is that whatever they wanted to agitate under 13, whether that has been addressed or not.
yes.
And then we'll see, Lordship, whether if there was some informative, whether that has been taken care or not. If they're not been taken care, then court will pass the necessary order. So, Your Lordship, as per the court's order of 29/11/2013, I shall proceed to consider the appeal of so-and-so. Now, Lordship, this line is important, Your Lordship. During the personal hearing. So technically in the 13, normally appeals are not heard in person because it's a matter of documentary evidence. But here, Lordship, the petitioner was heard in person. The appellant stated that nothing more to add than what has been submitted in the appeal petition.
No, this is nothing.
This is not relevant, Lordship, but then he had an occasion to, besides petition, he had a chance to further clarify in terms of hearing. The disciplinary proceeding was drawn up against the appellant on 1/2/2001, which following articles of charge framed against him on the statement of allegation. You did not, and this was the allegation, Your Lordship, you did not assert utmost vigilance to prevent the escape of prisoners on 18/11/99 from Tura jail as required under 93(1) of the Assam manual adopted by Government of Meghalaya. You opened the inner gate of the jail to call out one of the wardens inside the jail, thereby allowing the prisoners to snatch the keys of the outer gate from you, open gate and flee. This is a contravention of Rule 202B and Rule 202C and Rule 203 of Assam Jail Manual as adopted by Government of Meghalaya, rule enclosed. An inquiry was held in the allegation in the inquiry officer on first article of charge. The IO found that appellant did not assert utmost vigilance to prevent the escape of prisoners and thus failed to discharge his responsibilities. The IO also found that the appellant did not exert any vigilance worth its name and failed to make use of peeping window. This is important, Lordship. This is based on the now the appellate court is appreciating the IO's inquiry, Lordship. So the IO also stated that the appellant could have used the attached toilet, which is the main gate in the office room itself, even without being relieved by anyone, if the so-call of nature was so exigent in character. The absence of appellant for a few minutes would not have made any difference if he leaves his post after securely locking the gate. The IO also found that the other charges against the appellant, that he opened the inner gate of the jail to call one of the wardens inside the jail and thereby facilitating the prisoners to snatch the bunch of keys, open the outer gate and flee as proved beyond doubt on the ground that there was many alternative means to communicate with the prison inside the jail. The gap between the two iron doors of the inner gate could also be used to communicate with the prisoners to call the warden on the duty to relieve appellant without opening the inner wicket door at all. The IO thus found the second charges on negligence as proved beyond reasonable doubt. By order dated 13/9/2007, the disciplinary authority had issued the removal of service after considering the inquiry report and statement of defense. The first appeal petition Shri Singh before the CS President was disposed of on 9/2/2009. Subsequently, the Director General of Prisoners, by order dated 12/4/2012, and after considering the inquiry report of Tura Magisterial Inquiry Report and other records, upheld the charges on dereliction of duty and awarded the appellant the major penalty of removal of service. Lordship, for a moment, I'll just pause here. Besides the normal inquiry, there was also a ministerial inquiry. That also found clear clinching evidence. So this appellate authority under 13 also relied. Besides the inquiry report, it also lent credence to that ministerial report.
See, the magisterial inquiry report, was it brought into the proceedings? Disciplinary proceedings?
No. Lordship, correct. That was not brought. But in this, that's why, Lordship, I paused for a minute. In this appeal under 13, while appreciating the inquiry report, it also considered the ministerial inquiry report.
That cannot be.
Lordship, correct. That's why I thought it was brought to the knowledge of it.
We'll ignore that part.
That part we can ignore. Absolutely correct. Lordship is correct. That was not the subject matter, but it had considered it. We can ignore that part. Lordship is correct. The appellant was cited several procedural grounds for considering the appeal but the basic grounds of appeal cited by appellant is his action of opening the inner gate, resulting in his being overpowered by prisoners and their escape. On the basic ground of appeal, the appellant stated that he could not have felt the presence of 27 inmates of the jail near the inner gate, that he could not have used the window to see if any inmates assembled by the side of inner gate, as though the window only straight view could be seen and the side view is not possible. Hence the inquiry officer is totally wrong to hold that the appellant did not exert utmost vigilance to prevent the escape of prisoners. This was the contention raised that the inquiry officer was wrong, while appreciating the facts, Your Lordship. And I'm afraid, Your Lordship, if it is a case of no evidence or perversity in the facts, then maybe appellate authority or this court would look into that. But here they're saying it was wrong in coming to a wrong inference on the basis of fact. So the court will look into that part. Appellate court at least looked into the part and agreed to consider that whether it is wrong or right. Now then we go ahead, Your Lordship. Secondly, the appellant also stated that he could not have used the attached toilet, which is the main gate in the office room, as they were out of condition, and hence he made all attempts to call the inside duty staff to relieve him due to call of nature. When none turned up, the appellant opened the inner gate to call other duty staff in jail, at which time the appellant was attacked and the prisoners snatched his keys and fled from the jail. The appellant also submitted that the grounds for appeal, such as IO refusal to cross a single witness and non-furnishing of certain records, letters, memos by IO to the appellant, besides delay in the inquiry. After going through the records, I find from the ministerial inquiry, Lordship, this we can ignore. Lordship is correct. The gross negligence and careless by opening the inner gate of appellant led to the escape of prisoners with no possible grounds and accounts of dereliction of duty by the appellant. Now, while the appellant was on duty, the gatekeeper of the ministerial inquiry also concluded that it has not been an unforgivable mistake of the appellant. The entire situation would have been saved, and therefore he is responsible for escape on 18/11/1999. The magistrate also indicated that since the incidence of the same modus operandi, being second in this time on duty in the gate, is a mistake that cannot be taken for granted, the appellant is not a person to be trusted anymore. Lordship, I'll pause for a minute here.
Yes.
The material finding of ministerial inquiry report may not let so much credence, but at least this last part, court may take a judicial notice. This is very important, that this is a second incident. No, we are not going into the merit of the incident.
Even at this stage, cannot take judicial
Lordship
notice.
is correct. But
for the reason that the principle of natural justice will apply.
Lordship is correct. But the appellate authority, a situation had presented itself before an appellate authority that they on the basis of ministerial inquiry report that this was the second case. Now I leave it to the court, Lordship, where the court will at least only take a judicial notice that this is the second case.
Either that,
and
or
they have not.
either that, or the appellate authority can remand the matter back to the, inquiry committee. And
Lordship, yes. Or we would consider it.
That could have been done.
Yes.
But
Yeah, I'll leave it to the court whether if court feels like wants to take judicial notice of that. If not, then leave it to the court. Now, Lordship, so this paragraph technically sounds irrelevant for the present purpose. Now we come back again. We continue with the IO's finding. From the IO's finding and other records, it is thus evident that the escape of prisoners on 18 line from district jail was primarily because the appellate opened the inner gate, resulting in its being overpowered by prisoner and the escape. So, this opening of the inner gate and escape is clearly a finding of the IO, which they have also made an oral statement before 13. So, this finding, Your Lordship, is very crucial. Both the inquiry officer report and ministerial inquiry reports pointed to the fact that appellant was sufficient experience as a gatekeeper. We'll remove the ministerial inquiry, Your Lordship. We'll not read ministerial inquiry. Both the inquiry, we'll just read the inquiry officer reports pointed to the fact that appellant with sufficient experience as gatekeeper failed to utmost vigilance and negligence in the discharge of duty as a gatekeeper by opening the inner gate. Lordship, again, pause for a minute. Sufficient experience means he was a very experienced person in the jail. We can understand if it was 1 year, 2 year, lack of experience. A man with great experience and then 27 inmates just outside the gate. So that the conduct of the petitioner is very important here, Lordship. Knowing fully well that if the gate is open, he can be empowered. With that experience, there is a serious lapse.
So he is well aware of the procedures.
Absolutely, Lordship is correct. If Lordship, much obliged, Lordship has clarified that. I was just coming to that. Experience would be he is aware of the gates and he is aware, like, any lapses, minor lapses could cause a major catastrophe in terms of escape. And he's all aware of where the gates are, where the locks are, what is the timing of prisoners, where are the washrooms. So with that experience, minor lapses, Lordship, could be very risky. We have to see the context, Lordship, in a proceeding like this. The consequences of lapse, if there are very little consequences, Lordship, then court will be very lenient. The consequence is so drastic, the 27 inmates disappears. And if the lapse is just not bolting the gate. So Lordship, he's a man of experience. As an experienced gatekeeper, he could have well understood the danger of such an action. That's exactly what you were saying. Danger, Lordship, if we just explain the meaning of this, the consequences of even a minor lapse.
Yes.
His argument that the toilets, which is the main gates and office room itself, are out of order and could not be used, cannot be taken on face value. Moreover, he could have used the gaps between the two iron doors to communicate with the prisoners to call the warder. This is very important, Your Lordship. Opening the gate, if he was if at all as an experienced person, he could have shouted, called, and he knows the place where to call the warden, where the prison is. While examining the records of inquiry, I find that the IO has given the appellant sufficient opportunity to be heard and to defend himself. The procedure prescribed, Lordship, before I go to this paragraph, till warden, Your Lordship, I've just gone through in detail. The appellate authority has relied on the documents and also heard him. So there's often use of the word statement made by appellant and then submitted. So it is not the case only that the appellate authority was going through only on the record, was also giving him a hearing opportunity and giving an opportunity. And some of the facts which are recorded in his order are based on his statement. And if I may submit, Your Lordship, allow me to go a bit slow, if I may submit, had it been only in appreciating the documents of the IO and the finding, the appellate authority power would have been circumscribed by only documentary evidence. But hearing, Your Lordship, is almost like another kind of an inquiry. Now, only appellant was heard, not the state officials. So he had all the chance to explain, and there's a discussion on hearing and statement. So, Your Lordship, now if you come back to that second last paragraph, again the appellate authority says, while examining the records of inquiry. Before that, it's examining the records, statement and personal hearing. Now he comes back only to the record. I find that the appellant has given the appellant, IO has given the appellant sufficient opportunities to be heard and also to defend himself. The procedures prescribed in the disciplinary rules have been compelled with, and the appellant has been given sufficient opportunity to defend himself on the allegations and show cause notices. Now, while examining the records of inquiry, I find that IO has given his finding on the statement of allegation and not specifically on the article of charges. With the result that his finding is not specific as to each article as they could be. This was argued at length, Your Lordship, by the petitioner. But then the explanation is given in the next line, Your Lordship. Even so, no material illegality has been committed by IO and no injustice has been done to appellant. There is no evidence of bias on the part of authority concerned.
Yes.
Your Lordship, had this explanation not been there,
Yes.
now if there was no specific, the statement of allegation are not specifically on the article of charge, and if it would caught bias or prejudices, Lordship, that should have raised at the first point of time. Now, appellate authority says there is no evidence of bias on the part of authority concerned. Given the facts and circumstances of the case, the penalty of removal imposed on the appellant is appropriate. Therefore, I find no reason to interfere with the order of 12/4/2019 and Director General presents the appeal petition accordingly dismissed. Copy of the order sent to the appellate through the DGP with receipt, acknowledgement and to the authorities concerned. So, Your Lordship, appellate authority has dealt with inquiry officer finding. Magistrate inquiry, Your Lordship, for a moment will keep aside. Lordship is correct. That has unnecessarily crept us, creating more confusion. Finding of inquiry report, detailed discussion on the allegations, also on the finding, peeping hole, use of warden, use of gate, all these. It not only it has discussed the records, but it has also ventured out to discuss the evidence. And while discussing the evidence, a personal hearing was also given. Now, if personal hearing was given, Your Lordship, at this stage, it adds more credence to the appeal petition, because the appellant, or rather the petitioner as an appellant, could have, when personal hearing was given, could have brought on record some of the prejudices, some of the objections, could have asked for leave.
No, but the fact remains that, of course, there's an observation that a personal hearing was accorded,
Lordship.
but his submission was not recorded.
In some part, Your Lordship, is stated. I'll just come to it, Your Lordship. Some part here, the appellate authority has mentioned, Your Lordship. Lordship, we just come to page 91,
Yes.
1, 2, 3, the fourth paragraph.
Yes.
Secondly, the appellants also stated that he could not have used the artificial toilet, which is the main gate in office room.
Okay.
The Lordship is correct, like I will not press this part too much, but the word personal hearing is used and the word stated. And then if we come to page 92, para 2, Your Lordship, then it says, while examining the records, we don't know the mental process of the appellate authority, Your Lordship, but we have to go by the literal meaning of the word, especially when personal hearing was given. There's some.
But you say that in an appeal proceeding, personal hearing is not so much
No,
required?
Lordship, technique normally it's not required. Lordship is aware of this. It's not required because it's an appeal against this 13. But this was a
More
case
often
where,
than not.
this was a case where personal hearing was also given. So the moment personal hearing is given in Lordship, principle of natural justice demands the other side should have also been heard. One, we are not pressing on that. What we are pressing is this, Lordship, where personal hearing was given. Besides the application under 13, he had an opportunity to bring in all the illegalities, or infirmity, or lapses, or documentary proof. Keeping aside the lapses and infirmity, he had an opportunity to bring on record certain facts which he could not have brought, or he allegedly he says he could not have brought before the inquiry officer. So he had an opportunity. Now he chose to waive that part. He chose to waive the part. There is no mentioning on that, Your Lordship. Had there been mentioning, Your Lordship, at least I could have got a chance to reply, or maybe they would have a chance to argue. So he has not done that. And then the most important part of this appeal is this: everything has been considered. And Your Lordship, we will just come back to the application under section 13. What was the main ground If we come to the yeah, page 68. Thank you. Page 68, Your Lordship.
Page
668.
yes.
The relevant part, Your Lordship, is at page 71, second paragraph.
Yes.
The first ground that the important ground, Your Lordship, against 12/4/2012.
Yes.
If I may allowed to read, Your Lordship, upon receipt of the inquiry report being furnished by Director General, appellant filed a representation dated 31st March 2012 against the removal from service. The Director General had mechanically and most arbitrarily passed an order 12/4/2002 rejecting the representation of appellant by awarding him the major punishment of removal from service. Allegation was mechanically and without most arbitrary. The next line, Your Lordship, the said order is not speaking order and being highly aggrieved by the impugn order, the appellant prefer this appeal amongst other points.
Yes.
So, Lordship, 13, this present appeal under section 13, Lordship.
Yes.
Lordship, if you go to the substance of section 13 appeal, the main substance, Your Lordship, for challenging Director General's order is that it was non-speaking.
Non-speaking.
It was mechanical.
That is,
Lordship, correct. If that was the case, Your Lordship, that ground still remains under 13.
yes.
They have narrated the facts. We are not denying it, Your Lordship. Everything has been covered up. But the main thrust, Your Lordship, will correct because we have to fortify what are the parameters in which they want to challenge the order. If it was non-speaking, Your Lordship, and when they file an appeal under 13, Lordship, I have read out the order. At least this order has got two important components. If you manage the ministerial inquiry, it has appreciated the inquiry report in detail. Number one, it has recorded the statement and also appreciated the findings of it. So first thing, Your Lordship, that would come is this, the order, the impugn order, the last page, which I read, page 90. It is a speaking order, Your Lordship. If they were prejudiced by Director General's order of not being a speaking order, but whether court will have to appreciate whether this order is speaking or not. If it is speaking order, Your Lordship, the main challenge of the ground has been met. Then the second issue, Your Lordship, would be if it was a speaking order, as it appears prima facie, then what are the other grounds that they are assailing? And whether the other grounds are they assailing on the ground of perversity? That means inquiry report itself was, nothing was in the inquiry report, no finding was there, nothing was there. Yes. That is not the ground before the Honorable High Court, Your Lordship. They are not challenging this impugning order. So the cause that they set out by preferring an appeal was the previous order was non-speaking. Now that cause has been answered in the appellate authority's order. Now if that has been answered, now what is the scope of this court now? That would be the first ground, Your Lordship. First ground that they have to answer. If it was perversity of evidence, wrong finding, no evidence, prejudice, then Your Lordship, we have to go back to the inquiry report. We'll have to go back, and we have the record also, Your Lordship. We can give to the court also. Whether that is the case, then court we have to go through detail wise.
So whether the copy of the inquiry report.
Your Lordship, yes, she has read out that detail, Your Lordship, but she had done it. 50.
Oh.
But if Your Lordship wants, we can go through it again.
No, what do you mean to say?
It is there in record. It is there in record. Lordship,
if you want to produce it in, as a matter of course, I don't think it's necessary.
No, absolutely, Your Lordship, absolutely. Your Lordship, what I'm saying, I'm just trying to segregate, isolate two important arguments in matters like this, inquiry. If it is case of non-speaking order, court will have a very limited scope, which has been answered by the appellate authority, and they have not challenged in the writ petition. In spite of the fact this is a non-speaking order. But if it is their case, in spite of all this process being followed, they are still prejudiced because the inquiry officer has not given them a chance to cross-examine, have not given a chance to exhibit documents. They were suffered.
And whether the appellate authority has dealt with those issues.
Lordship, yes, it has. Lordship, I read out everything. It has been dealt, relying on the.
So that is basically the
absolutely
case.
So that's why, Lordship, we have to isolate both the arguments and take each one. Now, I have answered the speaking part. Then the second part is, Your Lordship, whether the inquiry report itself is vitiated.
Yes.
Your Lordship is aware of a very limited ground. Court will not unsettle the finding. Court will not unsettle the finding.
Finally, the court will not, go into the merits of the evidence.
Absolutely, Lordship is correct.
That
has been, Lordship, the second part. Speaking order part, I have answered it. The second part is the merit. Lordship, I have read in detail. It has gone through the findings. It has recorded everything. Now, we can appreciate, Your Lordship, one thing. If in a writ petition, they challenge the order of 25 to 2012, page 90, saying that this appellate court's order, which has upheld Director General's order, which in turn had given a stamp of approval, this order itself is illegal. It's almost like a Lordship second appeal. I'm just drawing an analogy of second appeal. Let's assume this is an appellate court's order. So then the question would be whether a substantial question of law, just for the sake of analogy, Lordship. But it is not the case that this entire order is wrong because all the facts recorded or everything done has grossly overlooked the inquiry officer's report, has grossly not considered a fact. That is not the case. If that is not the case, that they have not challenged this order itself as saying grossly overlooking the Director General's order of not speaking, grossly overlooking IO's finding, and everything from IO report to Director General now speaking order, everything is vitiated. Lordship, if that was the case, then what was fallen from your Lordship was if there was something wrong in the inquiry itself. The finding could not have been what the finding ought to have been because of certain lapse. We'll have to do microscopic appreciation of evidence, and if there is an area where things have really gone wrong, court will stop at that point, set the clock back.
Yes, of course.
Lordship, is that situation in this case? My respectful submission, Lordship, that is not the case of the appellant. And third, Your Lordship, it's a removal. It is also not the case of the writ petitioner here that removal was disproportionate. I'm afraid maybe I'm just giving few hints to my friend here. Then court would have...
Yes, because you see, now the issue of, let's say for discussion's sake,
Lordship, yes,
between removal and if we go into the proportionality of the, the whole, matter.
Lordship, I'm just trying to be fair to the court.
Perhaps removal could be, converted to dismissal.
Lordship, that is not the case at all.
Sorry, compulsory retirement.
Yeah, absolutely, Lordship, that is not the case at all here. The case here is to quash the inquiry report, quash the DG report, quash this, saying I was not given access to this. And that was the second isolated component. But had that been the case, Lordship, then we had to go back to entire records, and if Lordship finds anywhere violation of national justice, serious prejudices caused by not giving an opportunity. Lordship has dealt with a number of cases, and I would also concede to that we have to stop the clock there. Nothing will happen, but we have to start fresh, giving opportunity. That is not the case. Third option, Lordship, would have been removal access. And if for that, Lordship, we just come to the appeal of the prayer in page 19. It is not the case, Your Lordship, that in spite of the fact of appellate court order giving a speaking order, the issue of speaking order being addressed, they have approached the court because removal was excess. Court would have to apply the principle of Wednesbury principle of law and would have assumed the primary role, Your Lordship. The moment disproportionate comes in, Your Lordship, then court steps in and says, I can as Lordship rightly said, it can convert.
Because the reasonableness aspect may have to be gone to.
Lordship. But that is not the pleaded case. As I said, Lordship, you take page 19, the prayer. I was afraid, Lordship, I'm just trying to help my friend. Even if they wanted to build up a case, they could have built up a case on that. And then Your Lordship, the quality of evidence. That would have been third level of argument that normally happens in a DP cases. Would have been a very interesting argument and fit for this case, where we'll have to appreciate the quality of evidence, the warden not locking the gate, the appellant not locking the gate, not calling the warden, in spite of being an experienced person, his lapse. Now, we would have had a very limited scope to appreciate whether that lapse was such major lapse that the consequences was 27 escape or minor lapse. We had to appreciate the quality. The consequences of the lapse was 27. Then as government counsel, I will say the removal was justified because of his experience. Now court will try to refute whether in spite of the experience of this lapse, will it amounting to removal as service. I'm afraid, Lordship, this case was a fit case, and at all we would have ventured out for that. But that is not the case. This was again, Lordship, just to casually inform the court that where possibly this case should have gone after the appellate court order. Given the facts and circumstances, Lordship, I will not waste much to court's time, except if court has got query, then we'll have to rely on the documents. That's the second part of the argument. The first part has been answered. The second issue that normally happens in a DP absolutely has been answered by the appellate court's order in a detailed speaking finding. Third, Your Lordship, it is not the case that they are challenging the appellate court order, the final order, saying that everything is vitiated because these factors are not done. So that has to go.
Yes.
So that is also not the case, Your Lordship. If that is not the case, then the third argument is not before the court. So my respectful submission, Your Lordship, there is no merit in this appeal.
You brought the records with you.
Lordship, records are here.
So in the records, you will have the recording of
yes.
the deposition of the witnesses.
Some because it's quite an old case, Your Lordship, way back, and so we could trace the record and the findings, and they have relied on the inquiry report, Your Lordship. Important thing is this: they have relied on the inquiry report. It is not the case there is no inquiry report before the court. She read out in detail, and we all appreciated her when she was reading it because she was doing well on getting those finer points. But ultimately, there is no infirmity in the report, and it is before the court.
Yes.
So, Lordship, my respectful submission, there is no infirmity. The issue of removal has been rightly upheld by the appellate court, and the grounds that ought to be challenged, it is not there. So, this is a fit case where there is no merit in the appeal and it ought to be dismissed.
Yes.
My lord, I have prepared a bullet points, my lord, whatever I have argued on the last occasion, my lord, if I am allowed to submit, my lord.
Bullet points of your reply or your argument?
On my argument, on the whatever I have argued on the last occasion, my lord. And my lord, here, my lord, I am relying on two judgments with regard to the violation of this.
Have you noted those authorities in your
No, my lord.
synopsis?
I have supplied a list of books, my lord.
You could have done a comprehensive written argument,
That I
so that referring to your authorities cited
my lord.
and the relevance and all those things.
My lord, on the issue of that, there is no finding on each article of charge, my lord. On that issue, my lord.
So you do that, Mr. Khan. You similarly file a written synopsis of your argument.
Small one, okay, Lordship, what I have submitted.
Whatever. And also the record to be produced before the court.
We'll submit to the court.
The records are they are no longer required, I believe.
No. The inquiry report, Lordship, is a part of the petition.
So you can deposit it with the court, with the court master.
Writ petition is part of the writ petition inquiry report.
Not the inquiry report. The records wherein your recording of your deposition of your witnesses are there. That would be relevant as far as the court is concerned to understand the background.
We also may be allowed to go through once the record whether there is any witness has been examined or not, my lord. As per our submission, my lord, there is no witness has been examined.
Are you
No,
privy?
Lordship, as I submitted, Your Lordship, for that to
To that
address.
effect also, there is no finding that any witness has been examined and all, my lord, in the inquiry report as well as the finding of the appellate authority, my lord, order of the appellate authority. There has to be some recording with regard to PW1.
But even record for that matter. See, nowadays everything is transparent. Even if you don't give it to them now, they can apply it by RTI.
Absolutely, they can do it.
So you might as well.
But Lordship,
Since the record is here, my lord, if my lord allows us
no,
to.
we'll give it to the court, some recording of the statement.
Hand it over to the court, and you can. The court master will arrange for it to be produced by you.
We'll be basically relying on the same inquiry report that they have annexed.
Exactly.
Whatever they have supplied to me, there is no
they can
recording
apply
of
on
any
RTI.
witness or anything, my lord.
Fine.
Okay.
Heard land counsel for the Mr. K. Khan, Leonard AAG, appearing for the state respondent. The argument having been concluded, the parties are, as submitted by the parties, the synopsis of the written argument may be filed along with the authorities relied upon by the parties, may be filed for this court within the next date fix. In the meantime, Mr. Khan has submitted that the relevant records of the inquiry proceedings against the petitioner herein are produced before the court. The same is now in possession of the court. The petitioner, if so desired, can produce the contents of the set of the record. This is matter 2 weeks.
Item number 7.
Your Lordship, I have seen about this matters as regard to the legal points of this service. So you will see here, in presumption and rebuttal the presumption, I have checked up. So there is no substantial documents they have produced. It has been served in our office. So you will see in this case, whatsoever she has given other correspondence, as per her, yes, I've gone through this record, and this has been replied. And in such situation, the 2 letters whatsoever she is editing, just no reply is given. She is given only the postal receipt, and whether it is rightly or wrongly addressed, because she is not given any report towards the service to us. So if you come to this Lordship, this petition page number 23.
Page 23.
23, annexure 8.
Yes,
May I read, Your Lordship?
please.
Reply to the Sokos notice. Humble request is that kindly pursue your letter number such and dated 6 December 2012. I would like to inform that my husband, such and such rifleman Kumar Singh, was died in service in the 1992. To cater the needs of my sibling, I have been rendering my service with almost dedication. Yes, sir. I am uneducated ready. I was on leave till 15 November 2010. In between this, my son Chandra Singh was implicated in a case under Dowry Act. In this case, I was also arrested. So she was arrested by the police. After much trying, I was granted bail on 16/9/2011, and my son was granted bail on Student said, again, they said I was granted bail on 9/1992, but my son was jailed 51/12. There was no one to look after my son except me, for which I could not join my duty. This was my wish. For your kind perusal, bail order are submitted herewith. That's sir. After the bail, I have been running from pillar to post to settle the matter, so that I could not join my duty. Sir, I have intimated my inability to join duty by my various letters written by others. The dates on which are letter are as follows. So she has mentioned here this 4 letters.
Yes.
You will see. So they said the date has been fixed before this court, and I have to comply with my sons on the date. Recently, a date has been fixed on 6/10/2012. Therefore, I request to kindly forgive my fault so that I could earn the livelihood for my family. So this was the this. So here it's if we come to this our reply to this our affidavit, you will see. You will see when we got the letter issued by her and it is received in the office, then it is replied accordingly. You will see in our reply, page 23, our affidavit.
Page?
Page 23.
This one. This is your bid dated 13 March.
Yes, you will see.
Just check.
It is in the month of March, March 2018.
What does page 23 says?
So this is the reminder number 3 for
Okay.
joining duty. So earlier also some reminder is given. So this is the one of the reminder.
Yes.
So in this fellowship, this in reply to our letter number as 30 January 2011, you are informed us on 22nd February 2011. So this is the in page number 23 petition. This in paragraph 6b, letter date 22nd February 2011. In paragraph 6b letter, this referred 22nd February 2011. So this letter has been replied.
This letter was written in.
So you will see letter is not there, but it is dated. It is exactly same 22nd February 2011. So it is given to inform us on 22nd February 2011 that you are not healthy. When you will be fit, then only you can join your duty. But you are still absent. So please intimate when you will be fit and when you will be join duty. You are continuously absent with effect from 15 November 2010. You are hereby warned that if you will remain absent without any reason, disciplinary actions will be initiated against you and you will be dismissed from the service because you are absent with from 15 November 2010 till date. So you will see after having this 22nd to 2011, even if you forget about 25/12/2010, but that time also we have given her opportunity to join her duty. So if we ignore this one, this earlier one, we didn't give any response. Then also second letters, it is specifying this, even given when she will be fit to be joining the duty. And subsequently in this next letter you receive in reminder 4. Page 25, that could be receive.
Yes.
This Your Lordship, in writ petition page number 23, paragraph 6 and D, dated 23 July 2011.
Paragraph 6D.
D, dated 26/7/2011.
Just a moment. Yes, please.
So, in reply of this, Your Lordship, thus, 28 September 2011, Department has given the reply. Received your letter of July month, because there may not be the date as given in this letter, in the month of July, maybe July month, so it is a July month. You know very well that you are absent with 15 November 2010 to till date. The matter is against the service rule, so please intimate that when you will be join your duty. So again, she has been informed that to know about it when she will be going to duty. You are also informed that there will be no leave due, so no leave can be granted to you anymore. Therefore, you join your duty forthwith. So you will see here, if we even ignore 25/12/2010 and 11/5/2001, this was we are saying this, we didn't get the these letters we have given, and they are saying this is the letter, and content of the letter also then they cannot say. So if you ignore even this two letters, subsequent letter you will see, we allow her to join her duty, but she didn't come up. Even she didn't inform these matters about this reply given the shockers that she was even arrested. She was saying earlier this is not healthy and she will not be in a position to join her duty. So, Your Lordship, there is nothing wrong to take action against her because she has suppressed the material facts. Even in the department proceeding also she didn't express these matters, and then only these shockers when come up, then only she has given. And she could have come in clean hand that says some problem is there for anyone and she has been arrested, and she could have informed, but nothing is given. So this is the two letter before this honorable court, this act to substitute whether service is done. So even considering this, even it has been even served, and subsequent letters when reply is given her the opportunity to join. So there is nothing strong on the part of this department, and if that letter is not available even, and there is no cause of surviving out of these letters.
So even if those letters are not in records, it will not, have any bearing, or
It
will have no impact on the
yes,
outcome of the case.
Yes,
that is your assumption.
This Mr.
Lordship, may please your Lordship. If your Lordship come to my petition, page 39, annexure 14, where I petition to the appellate authority.
Page number.
In my letter, I've clearly stated, your Lordship, pertaining to this court order, pertaining to my arrest and everything, based on the court order, your Lordship. So nothing material has been concealed.
Page 39.
Page 39, annexure 14 of my petition.
Not there here.
Yes.
So I rebut to what my learned senior is saying that I have concealed. Nothing has been concealed. If your Lordship, if I may read, it is a letter to the appellate authority, Assam Rifles. Subject and appeal preferred under section 22 of the CCS rules, 1965. Reference, I have referred to my impugned order, your Lordship. In the body of the letter, I have written, with due respect, I have the honor to inform you that I was working as a female attendant in the Assam Rifles since my initial joining on so-and-so date. Aggrieved by the above referred order dated so-and-so, I preferred a writ petition bearing so-and-so before the Honorable Gauhati High Court. The Honorable Gauhati High Court was disposing of the writ petition by the order so was pleased to hold that I was given a fair chance to prevent an appeal as applicable, further permitted to file an appeal as provision and provision of law. Hence, this appeal is preferred before your Honor, with a prayer to cancel the impugned order dated so by allowing me to resume my duty as soon as possible. Then that, sir, my husband was died in active service in Jammu and Kashmir due to buried snow slide in the year 1992. On being applied, I was appointed on compassionate ground as female attendant. Now at paragraph 2, your Lordship, that, sir, due to some urgent family problem, I took leave of 26 days including 2 earned leave and 6 days transit leave from such date to such date. Thereafter being requested, I was allowed leave till so on such date for a period of 20 days. However, due to some family problems, I could not resume my duty on the expiry of the leave period. I duly intimated my inability to join my duty to the higher authority. So, Your Lordship, the family problem that I've quoted here is the very fact that I was arrested, my son was arrested. That so nothing material has been concealed. That is my submission before Your Lordship. Subsequently, also,
Okay,
Your
so
Lordship,
this is the on the strength of the order passed by this court, wherein you were given the opportunity to file an appeal.
Your Lordship.
So Annex 14 is your appeal.
Yes, Your Lordship.
And how is this appeal dealt with?
I have to seek instruction, Your Lordship. I'm not aware of this appeal.
No, you see, now I think the matter is clear.
Lordship.
Ignore about what had happened earlier. You know, even correspondences missing here and there or whatever.
Lordship.
You ignore that.
Lordship.
Now, what would be your what would be your contention before the court? Would be now you have been given the opportunity to appeal before the appellate authority. That you have done by this appeal.
Your Lordship.
And subsequently, this appeal must have been dealt with.
Annex page, Annex 15, page 44.
That is, just a minute.
The operative part is paragraph 7 at page 45.
So page 44 is the where the
Order
appellate
has been
authority dealt with your appeal.
Lordship.
Okay.
And the operative part is at page
Just a
45.
moment. So now this is
So
this
against
is the
this,
response
against this
to
order, we have come before Your Lordship.
against this order.
Your Lordship.
I think basically we have to concentrate only on your contention as to how this order is perverse, or how is the order not maintainable,
Your Lordship.
or whether
To that effect, we have filed our written argument. We have both filed our written argument. So I think that will suffice.
So
As it is also, Your Lordship, today it has been pending for judgment based on my learned senior seeking for time. Time has been granted time and again. So now he's coming up with this argument despite his filing of written argument. Now it's only for the deemed service that the matter has been
anyway,
pending
I
pertaining
think
to the deemed
that
service.
now that would become immaterial.
Lordship.
The matter has not been, perhaps not being fully projected before the court.
Lordship.
So Mr. Devnath, you file your written argument also?
Yes, Your Lordship.
Both parties are filed.
File, Your Lordship. At one point of time, it was fixed for judgment. It was just for the deemed service of those postal receipts which were.
So the matter will be posted for judgment.
So I'm giving this copy on this. This whatever I have argued, Your Lordship, same things earlier argued, and this copy I think in the court I've given. I've given to them already.
Sir, both sir, we have also received copies.
So that would be in the. And if you want to file an additional copy, you do it.
No additional, whatever I earlier argued, this same thing. Just I'm giving a copy to the court only.
Extra copy.
Yes, I have given. I think the last question whether I fill in this extra copy.
If it's the same, then I need not receive copy. If something new has been added, then I may be.
This I didn't change anything. The same thing. I
This is
didn't.
what I received. It looks different. Previously, I received 4-page argument. 8 pages.
This is the same thing. Sir, I'm giving you the copy.
Now he has given 7-page argument.
Here I received 8 page on the previous.
So this is the copy you received. What I give.
So give him a copy then.
It can this one. I
You
didn't.
want
I
to
didn't
go
change
through it?
anything. This is the
I
same.
have a copy, Your Lordship.
Do you want to add? Or do you want to refute this?
You can see now also.
If it's the same, then there's no issue, Your
Just you
Lordship.
can see now. You can verify now. Because I didn't take any new prints, so this is the same thing.
It has been reshuffled. The fonts have been reduced.
Just you can see this one.
Would you
It looks like
accept?
the same.
Would
No,
you accept it, or would you
Accept.
would you want to have time
Accept
to
it,
go
Your
through
Only
it?
so he can see this whether this page number.
I accept it,
since
Your
when.
Lordship. It is the same. Ditto.
Heard the counsel to the parties. That is now posted for judgment.
So this record was with me, Your Lordship. Record with you.
Oh, Swagato ne. Mr. R. Debna, CGC has submitted that the records pertaining to the case before this court is now produced for the court. The same is to be kept in the custody of the court till disposal of this matter. Matter is now reserved for judgment.
Item number 16.
It's the R3 matter.
Yes.
Item number 2 in the supplementary list also, and this matter also. I was praying today. Anytime next week.
What about there's no issue of
My lord,
settlement
my
negotiation?
instruction is that they are already talking at political level, my lord.
That is your stock, submission.
Well,
I have formal instructions on this matter that there is no such stock of settlement balance. In writing. Yeah.
Take up to a week, my lord.
So I was praying if this lordships could have it on Friday.
Not on a Friday.
PP Millards, there won't be too many matters.
Not on Friday.
Lordships may accommodate us on Friday if it's possible.
We'll have it somewhere.
Then next week, sometime on Monday or Tuesday.
We'll have it after a weekend. We'll see.
So then we'll have it on next Thursday. Then in that case.
It depends. If we'll have to. The court master has to look at the list. There are too many matters on a certain day. Then perhaps at some point of time it may be futile, for you to wait the whole day and so on and so forth. On prayer made by the respondent, let's this matter to 1 week. The other item that is
number 2 is the supplementary matter. Along with the supplementary matter. Both can be tagged together.
So that is also right for hearing.
Lordship, it is.
So same order to go back.
Supplementary item.
Supplementary.
Obliged.
Thank you.
Item number 21.
My lord, this is a case where the petitioner, my lord, he was charged under section 380 of IPC, my lord. What is the brief fact of the case is that, my lord, the petitioner.
Any private respondent?
Complainant.
Oh, that issue where
He purchased the goods and all, my lord, after it was missing.
Cement and rods and all the thing.
Right.
Yes, Lordship. He was the previous secretary of that very organization. That is the area
Employment Council.
Employment Council. That is under Mahatma Gandhi Rural Employment Scheme. So after his term was over, one fine day he comes and steals.
My lord,
So he
what
has
is the
confessed even before that.
But was the goods ever returned?
Yeah, my lord, what has happened is, my lord.
Yes.
Yes.
recovered.
Recovered.
It is recovered.
And it was purchased from his own money, my lord, and he will get the money
There is
back
nothing
only
on record. as such.
My lord, as per the scheme, my lord, he has to spend, he has to make the building construction, and thereafter, my lord, he will have to submit the bill. Thereafter, he will get the money, my lord. Now, here, what has happened is, my lord, he went to purchase the goods and all, my lord.
Sometimes, I know whether it is a case of mistaken notion or is it deliberate or.
My lord, yes, my lord, if my lord will see section 379.
Prima facie, he had completed his term.
Yes, and
So he
moreover,
had gone
completed
there.
the work. And now, my lord, nothing left. Already applications was filed before the district council also, my lord, by the complainant to withdraw the case, my lord. Because it was not compoundable, so, my lord, I had to come here.
Anyway, if you can satisfy this code, you will be let off.
Yes.
What's the point of keeping you?
Right, my lord.
Please tell me.
If my lord has a copy of the IPC, my lord.
Yes.
If my lord will come to section 378 of Indian Penal Code, my lord.
Yes.
My lord, here is the definition of theft. It says, whoever intending to take dishonestly any movable property out of the possession of any person without that person's consent moves that property in order to such taking is said to commit theft. Now, the petitioner herein is booked under section 380, that is theft in dwelling house, etc. Section 380, my lord.
Yes.
It says, my lord, whoever commits theft in any building, tent or vessel, which building, tent or vessel is used as a human dwelling or used for the custody of property, shall be punished with imprisonment of either description for a term which may extend to 7 years and shall also be liable to fine. Here, my lord, prima facie from the record, my lord, this is not a place which can be called as a dwelling house. This is what has happened is those goods were brought in and then it was kept in the open space. And
but we can use the term used for the custody of property.
Yeah, that is not a place, my lord, because here it says
once the property is deposited in certain place, so that automatically becomes a place used for.
Now, if my lord will come to the definition of definition that is given under 378, it says whoever intending to take dishonestly any movable property out of the possession of any person without that person's consent. Here, I am the person, my lord, I bought these goods. It is under my instruction, my lord, those goods were brought in and then mistakenly it was dumped in the open space, my lord. Fearing that these goods, my lord, these are perishable, cements and all, these goods were moved from the place by the family members and kept in a safer place, my lord. If we see by the definition of theft, my lord, the act which is involved herein, my lord, does not attract.
The goods were moved by family members.
Family members, my lord, not by me. Not by me.
Then how come your book?
That is what, my lord, and nothing has been done to the others, my lord.
Is there any evidence to that?
It is from the record also, my lord, will see these goods were moved by the other family members, not by me, and then charge sheet is only against me, my lord. And in fact, if we see by the sections, my lord, this is not attracted for me. It is in my possession. I am supposed to build the building, construction work. After completion of that one, my lord, I will get the bill. Now here, can I steal my own things from myself, my lord? This is very unique if we see by this way, my lord. This section itself is not attracted.
And moreover, my lord, in view of the fact that he is presently, if I'm not wrong, my lord, the Rangbasnam of this particular area, my lord. Now here, the complainants whoever at that time in my lord has filed the complaints, immediately after those goods were recovered.
And what is the nexus of the complainant with the goods?
Complainant, my lord, they are from village only, my lord. Those
They are the beneficiaries.
It is for the public use, my lord. Those buildings.
Yes, they were managing the entire exercise.
So, my lord, they went to the immediately, my lord, they went to the police station also to withdraw. But police, because they registered the FIR, my lord, they did not do it, my lord.
Non-compoundable.
Non-compoundable. Therefore, my lord, they went to the court also, my lord, that the matter may be kindly compounded, but it was not compoundable, non-compoundable case, my lord. Therefore, my lord, we had to come before this court, my lord.
Is there any settlement, deed of settlement?
Yes, my lord, it is already enclosed, my lord.
Where is it?
At page 21 also, my lord. And type copies at page 23.
No, this is the FIR.
No, this was written to the police station, my lord, to withdraw the FIR, my lord.
Yes, please continue.
Page 25 also, my lord.
Yes.
And then, my lord, page 27 also.
What is page 27?
That is an agreement, my lord. My lord will see.
Okay. I think this will be material. Yes, Mr. Guru, what do you have to say?
My lord, what my learned friend has projected before your lordship is completely different. Present case is completely different. In the sense that this is a typical case where lordship has noticed that business people burning their godown in order to claim for insurance and all. Here this is a case where the petitioner was the then secretary. His term was over, it was taken over by another secretary. It is not a case that he stole from his position. It is not so. As per the charge sheet, he has clearly said that he accepted the fact he had stolen.
That is.
It is there. Page 19. Kindly come to lordship the last paragraph. During investigation, the PO was visited. The construction site where the missing item materials were kept and situated opposite to so-and-so school. Few available witnesses were taken. Source information was engaged and later informed that the suspected accused was the former chairman of the AEC and also secretary of the so-and-so village. Shri so-and-so Kharkarang, on being led, shown and pointed by Shri so-and-so, son of so-and-so, village who had happened to be a witness, few of the stolen items were later seized from the resident of so-and-so Thaba, which consists of 11 numbers of packet cement, 2 number of 16 iron rods, and 12 iron rods, 24 numbers of 10 iron rods, 5 numbers of 5 rods. On taking a few steps of interrogation, the suspected person, Sri so-and-so Kharkarang, was found to be involved in stealing the cement and iron rod meant for the construction of the AEC building, to which he had firmly admitted and confessed to his crime of stolen the noted materials on being laid, shown and admitted by him, further recovered so-and-so. This is a case where
You have the CD audio?
I don't have it at the moment.
This would be, statement under section 161 or 164?
This is the
statement.
charge sheet.
No, this is charge sheet. What was referred to
That's
by the IO that he has confessed
I can obtain the
would have appeared in 161 or 164.
Yes. It would appear in that. Lordship is
No,
very
my lord,
correct.
even from here, the statement, my lord, which
Anyway, let him. So please continue.
That apart, Lordship, subject to my Lordship consideration, it's under 482. My lord, the law laid down in Bhajanlal's case, it is there. This is not a case where cognizable offence is not made out. Prima facie, there is a cognizable offence. Yes, I'll leave it to your Lordship.
You are appealing for? So you are the complainant. What is your stand?
Your Lordship, here I have no objection with regard to the petition because earlier also we have approached after the filing of the FIR, where the materials has been recovered, then we have approached the police also for the withdrawal of the FIR, but since the case has already been registered, so the police also were helpless. And thereafter, Your Lordship, we have also approached the court of the presiding officer for the compounding of the case, but as the section was non-compoundable, so we have to approach this honorable court, Your Lordship. So in that circumstance, Your Lordship.
What is the stage of the case?
It is charge sheeted.
Charge sheeted, my lord, I think.
Not yet. Evidence not yet.
Not yet.
That I don't know. Lordship, if I may submit, Lordship, recovery of the item per se won't sanctify the offence, Lordship. Won't sanctify.
Well, you see, Mr. Guru, you have to look at it this way. If there is, let's put it this way, an understanding or compromise between the parties, even if the matter proceeds, since evidence has not been recorded, what would happen? The complainant would come and give his evidence, his or her evidence. In all probability, he may turn hostile, which again would be, would affect the prosecution's case, and eventually, if the matter could not be proved beyond reasonable doubt, what happened? It all becomes a fruitless exercise.
Absolutely right. Absolutely. That is there.
Considering the fact that you see, even in cases you've seen in Narendra Singh and other Gyan Singh and other cases, even in cases involving section 307, even then, if there's a compromise between the parties, the court would look into the peculiar facts and circumstances.
It has got no impact on the society.
So, the only thing we can do is we have to tell the villagers to give him a few lashes. Like we used to be beaten by our parents when we steal sweets from the home. Then the counsel of the parties. And I heard Mr. N. Second, learned counsel of the petitioner. Also heard Mr. R. Gurung, learned GA appearing for the state respondent, and Ms. Harshana for the respondent. 3 to 6. Are you also in this case?
She's assistant.
I didn't see you assisting him. You could have given him some pointers.
He should be more vocal.
This is a case as presented by the petitioner, which would appear unique, if not comical, to the extent that the petitioner has asserted that he was accused of stealing his own goods and was charged under section 380 IBC, which in the factual matrix would not be attractive. The prosecution would differ with such contention and would say that the report of the investigating officer would show that the petitioner was involved in a case of theft and should be prosecuted in accordance with law. The respondents 3 to 6 in the meantime,
3, 4, 5.
where the complainant who has brought the fact of the theft to the notice of the police by way of an FIR dated. Where is the FIR? 7 May 2012.
8 my lord, 8 May.
8 May. So just correct. See.
Yeah, 8.
Have you annexed the copy of the FIR?
Yes, my lord, at Annex 1 only, my lord.
Page?
13.
File on 7.
1 3.
Filed on 7th and received on 8th.
Okay. Kunum to. Consequent to which what is the PS case number?
My lord, GR case number 185 bracket A
We will
2000.
go back to the PS case number first.
PS case number is, my lord,
Should be
40. Laban PS case number 40 bracket 5 2012.
Laban PS case number 40 under bracket 5 2012 under section
380
IPC. You will sit down.
Yes, sir.
The version of the petitioner is that he, as the former chairman of the AEC, what is the full form of AEC?
Area Employment Council.
Area Employment Council of Maukahir village in the East Khasiels district had purchased certain materials, including rods, isn't it? In your petition, you have written roads. You buy roads also.
Sorry, my lord, if there is.
Rods, cements, etc. for the purpose of construction of the AEC building. In the meantime, in course of the construction process, these said building materials were left at the construction site, exposed to the elements, which prompted the petitioner to secure them for safekeeping. The complainant, noticing that the said materials were not in the place they ought to be, had assumed that theft has occurred, and naturally the petitioner was the prime suspect of the same, hence the FIR. Where's the charge sheet? This is the charge sheet. Yes. The matter being investigated into, the investigating officer had, on conclusion of investigation, found a prima facie case under section 380 IPC well established against the accused petitioner herein, and he was directed to stand trial for the same. In course of the proceedings before the trial court, the petitioner has now approached this court with this application under section 482 CRPC, seeking indulgence of this court for exercise of its power, its inherent power to set aside and quash, to quash the said FIR, and to set aside and quash the subsequent proceedings, which by now has culminated in registration of JR case number 185 under bracket capital A of 2012, now pending in the court of the Learned Magistrate First Class, Subordinate District Council Court at Shillong. Without going to the merits of the matter, which would entail appreciation of evidence and the materials on record, which evidence has not yet been recorded. Suffice it to say that the petitioner has approached this court as aforesaid, along with the support of the complainant who, as submitted through the learned counsel, are now assured that it was a case of a mistaken notion, and that there actually was, and actually there was no theft involved. The respondents 3 to 6 respectively had even approached the concerned authority, including the Learned Court of the Magistrate First Class, seeking compounding of the offence to settle the matter amicably with the petitioner. The case in hand, in the opinion of this court, not involving an offence of heinous in nature, the submission of the parties at the bar would suffice, would be adequate to convince the court that a case for as case the last line. Is good. The case for grant of the prayer made by the petitioner is well founded. In fact, as regard the since the parties have come to an understanding and compromise amongst themselves, this court, relying on the authority of the case of Narendra Singh versus State of Punjab, thus I took a citation, wherein at para 29, the comma 29.1, 20.2 terus begitu mo, would agree that it would be a futile exercise for the proceedings to go on in the event the complainant would desist from proceeding further with their complaint. Accordingly, the petition is allowed, and consequently the FIR dated 8/5/2012 as well as the proceedings in GR case number 185A of 2012 pending before the said court of the learned first class magistrate is hereby set aside and quashed. Petition disposed of.
Second call from supplementary calls list, item number 1.
It is a 438 application registered under section 8C, 21C, 22, 23 and 29 NDPS Act. In connection with criminal NDPS case number 6/23 arising out of DRA case number 4 CL NDPS which is pending before the Honorable Court of Special Judge NDPS Shillong is Khasi Hills. Now, Lordship, the Panchnama is in page number 18.
Yes.
4 pages of Panchnama. I am saying in short. On 2010-2022, DRI officers on a specific intelligence about a Maruti Omni van having registration number so and so is carrying contraband and intercepted the said vehicle near Mauringking village, East Khasi Hills, at about 6 hours. On being signalled by the DRI officers to stop the vehicle, the driver of the vehicle stopped the car and parked it on the roadside. Thereafter, the DRI officers asked about the information of the driver.
You're reading from which part?
Lordship?
You're reading from which part? Page 18.
Yes, Lordship. My name, I am not the...
No, you're reading
the
which
petition, page number 3, Lordship, para 3.
Para 3.
Para 3.
Please.
Page number 3.
Page number?
Page number 3, Lordship. On petition number, on petition, page number 3, para number 3. On petition.
Petition?
Petition.
Okay, please read again.
Starting from...
Para 3.
Yes, Lordship. On 2010-2022, DRI officers on a specific intelligence about a Maruti Omni van having registration number so and so is carrying contraband and intercepted the said vehicle near Mauringking village, East Khasi Hills, at about 6. On being signalled by the DRI officers to stop the vehicle, the driver of the vehicle stopped the car and parked it on the roadside. Thereafter, the DRI officer asked about the information of the driver and co-driver of the said vehicle, where they are from and what is their destination, and if they are carrying any contrabands, to which the driver and co-driver introduced themselves and also stated their address and other details, and also informed them that the vehicle is empty. Thereafter, the DRI in order to search the vehicle took the same to DRI office, Longkirding, Shillong, and on searching the vehicle found a total number of 150 soap cases, and upon examination it is found that all the soap cases contain similar pinkish color substance suspected to be heroin, and after that they were arrested. But I am not those accused persons, Lordship. I am not the named accused in the FIR, but all of a sudden I am the landlord of the accused persons at Manipur. But all of a sudden on charge sheet my name is mentioned as accused number 3. Charge sheet in the page number 37, Lordship. Annex 4. As accused number 3, Lordship, Sri Obed Hamar alias Obedia Thik. And after that, the summon issued to me from the Court of Special Judge of Shillong. But on the last date, as I was suffering from jaundice, thereby I could not be appeared, and I represented by my counsel. But the DRI officers never approached me for any cooperation, never approached me for the investigation, but all of a sudden they mentioned my name is charged. Thereby I am apprehension of arrest, Lordship.
Yes.
Madam, the latest order has not been annexed. The petitioner has been charge sheeted, my lord. The lordship has seen.
Even the petitioner charge sheeted.
He has been charge sheeted, my lord.
But
can I just complete it?
But he was not arrested.
He could not be arrested, my lord. After filing of charge sheet, summons was issued to him, was directed to appear for copies, my lord, all the accused persons. Now, what he does, my lord, he sends a wakalat.
Why? How he was charged sheeted when he was not apprehended?
He could not be arrested, my lord.
His statement was not recorded.
His statement has not been recorded, but his statement nowadays under section 67 is no evidentiary value matter. But the evidence that came out in the course of investigation, he is the owner. It was found from the possession of two of the accused, my lord, who were driving the car.
You are the DRI.
I am the DRI, my lord.
Yeah. And this the alleged substance seized from them is
Heroin, my lord.
Heroin.
More than 2 cases, my
So
lord.
who would be competent to take charge of the case? Is it not the local police? Even if you have apprehended, you
No,
could
my lord. DRI is empowered, my lord.
Empowered?
My lord. DRI is a branch of customs, my lord.
Okay.
So they have the power. There's no dispute about that, my lord. DRI is fully empowered. In fact, most of the detection of narcotics and is done by DRI nowadays, my lord. So investigation revealed that the contraband belonged to him, my lord, and he was in constant touch with the other accused persons from whose possession has been seized. He has been charge sheeted, my lord, and lordship kindly sees the last page in fact, my lord, page 37.
Yes.
This is the order passed by the learned court, my lord. This is dated 12/5/2023. CR put up before me, seen the charge sheet filed by the Union of India, represented by so-and-so intelligence officer, Directorate of Revenue Intelligence, Shillong Regional Unit, so-and-so, against the following accused person. Darsang Lin is 1, Lal Roluk Hamar, number 2, and Ubed Hamas, this is the third, my lord. And the order perused the charge sheet. This court is satisfied to take cognizance of the offence and so register the case, fixed for production and copies. So instead of now, what happened, my lord? On the next date also he has not appeared. In fact, he is charged under 2 separate cases, my lord. One is NDP. This is NDPS case number
4.
This is NDPS case number 6, my lord. Yes, my lord. And on the last date, my lord, that was 27/6. Just yesterday, my lord. A bailable warrant has been issued against for his non-appearance, my lord. Because on 2 successive dates he did not appear before the trial court, my lord. And I can place it because what was passed only yesterday has just been uploaded, my lord.
In this case?
In this case, my lord. And in the other matter, because the order was uploaded, I can just place it, my lord. There also warrant has been issued against him. That is
the other matter is connected with this.
Two separate cases, both of heroin, my lord. That is NDPS case number 7, my lord. On the top, lords, you will see yes, CRL NDPS. And the present case is NDPS case number 6, my lord.
Yes, miss. How do you respond to this?
I don't have any clue about this case.
You don't appear. You come to High Court, my lord. The proper remedy for them is to go before the trial court and appear, my lord, rather than filing for anticipatory bail.
But in the present matter, maybe this
is the order. In the present matter,
accused petitioner may be grant. Because
here also, in this matter, I can.
Because in
it has just been uploaded.
Panchnama, in the entire
that is a matter of
criminal case, his name is nowhere mentioned.
That's a matter of evidence. Since the charge sheet has already been filed, so perhaps some credible evidence must have been, accumulated against you. Be that as it may, you have to cooperate with the process.
Yes, Lordship, I will appear before the criminal special judge and will cooperate the entire case, but kindly grant.
Can you appear?
Bailable warrant has been issued, my lord. He has to, subject himself to the process of the court.
No question of.
But in this matter, no bailable warrant is
issued. It has been issued yesterday. That's what I'll place it now. In this matter also.
Give a copy of the.
I'm taking a printout.
Can I see it?
Yes.
This is criminal NDPS case number 7/23, and this is 6.
Exactly. But as has been submitted, you are involved in both cases.
Both cases.
Arising out of the same transaction.
My lord, on successive, within a week, my lord, first consignment, that was even bigger, my lord. That is 3 kg something. And this one here is 2.2 kg, my lord.
But the ground for bailable warrant is
Lordship, seen Wakalatnama filed by Sri R.S. Sodial for the accused Obedia Thik Obed Hamar. However, the counsel is found absent on call. Seen petition for adjournment filed by the learned counsel on behalf of the accused Obedia Thik on ground that accused is suffering from jaundice. As none appeared to move the application for the adjournment, the same is rejected. And since the accused entered appearance through his counsel, issue BW for. It is not his fault, Lordship.
Anyway, but he has, you see, he has, he has appeared through his counsel.
But counsel is not moved the petition.
That is between the petitioner and the counsel.
My lord, this order, if I may read, my lord, this says NDPS case number 6 of 2023, 27/6/2020, CR put up before me, accused Darsanglen and Hamar, the other accused, are produced before the district jail.
Where is
from
it?
District Jail Shillong.
Which?
My lord, this I'm reading, I'll place it. Just been uploaded, my lord, because yesterday's order. Accused Obed Hamar is absent without steps, issue bailable warrant for rupees 5,000 against him. So and so.
This is in case number?
That is in number 7, my lord. And number 6, this is order. I'll place it. It's gone
but the petitioner is moving here. This is with regard to case number 6.
So here also, my lord, yesterday bailable warrant has been issued against him.
Anyway, let us not confuse the issue. As far as 7 is concerned,
that I'm keeping aside, my lord.
Yeah, that is a different matter.
In the present case,
we'll concentrate on the
yes.
6.
So in the present case, my lord, that is NDPS case number 6, my lord. The present case, your lordship will see the charge sheet was filed, page 37. I just pointed out, my lord. 3 accused persons are there. 2 are in custody, my lord. Number 1 and 2. Number 3 has not appeared in spite of issuance of summons by the learned trial court, my lord. And yesterday, when the matter was fixed again he did not appear, my lord. And so bailable warrant has been issued by the trial court, my lord.
Seizure was made from
from 1 and 2, my lord.
From that vehicle.
From that vehicle.
This is the order. Just to take. Yes.
Heard Miss Land Counsel for the petitioner. Also heard Dr. N. Musica, at DSGI, appearing for the respondent. The Land Counsel for the petitioner has submitted that the background facts leading to the filing of this petition involves an incident which occurred on 2010-2022, wherein a Maruti Omni van bearing registration number AS11Q9056 was intercepted by the DRI officers at near Mount village, East Khasi Hills. On the said vehicle being searched, a total number of 150 soap cases, which upon preliminary examination was found to contain narcotic substances suspected to be heroin. Hence, a case was registered against the 2 occupants of the said vehicle, and investigation was launched. In course of investigation, the involvement of the petitioner herein is found credible, and accordingly the IO has finally filed the charge sheet implicating the two accused caught with the said vehicle as well as the petitioner herein. It is the submission of the learned counsel that the petitioner is nowhere connected with the offence alleged, inasmuch as he is just the landlord of the two accused persons who were arrested in connection with the said case, registered as NDPS criminal CRL under bracket NDPS close case number 6 of 2023. And as such, apprehending arrests, the petitioner has approached this court with a prayer for grant of pre-arrest bail under section 438 CRPC. Dr. Musica, per contra, the learned DSGI has submitted that the fact that the charge sheet has been filed against the petitioner herein would show that there is credible evidence linking him to the alleged offence for which he has to stand trial. It is also submitted that the trial court had time and again given adequate opportunity to the petitioner herein to appear before the said court, but he has failed to do so. In this regard, the order dated 27/6/2023 passed in the said criminal NDPS case number 6 of 2023 was produced before this court, in which the learned trial court, finding that the petitioner herein is absent and without steps, had accordingly issued a bailable warrant of arrest against him. It is the further submission of the learned DSGI that the accused, that the petitioner should cooperate with the proceedings before the trial court and may be directed to present himself before the said court. Considering the submission made and the materials placed before this court at this point of time, firstly, it is noticed that this is a case involving contraband substance, and a case under section 21 under bracket C oblique 22 under bracket C 23 under bracket C 27A capital A oblique 29 of the Narcotic Drugs and Psychotropic Substances Act 1985 is involved. The very nature of the offence would show that the case is indeed serious. In fact, even the application of bail would have to satisfy the provision of Section 37 of the NDPS Act, which at this point of time could not be done so by the petitioner. Be that as it may, this court, on the facts and circumstances presented before it, is not inclined to allow this petition. Petition is hereby dismissed as devoid of merit and disposed of accordingly. Thank you.
Daily causeless, item number 1.
But this matter has been settled, Mel, finally.
Has settled.
Yes, ma'am. Yes, ma'am.
And where's the draft?
Is the settlement?
I can just place it.
Place it by way of an affidavit.
But only one aspect, my lord, because this was a dispute between husband and wife, my lord. The husband is in Manchester, UK.
Oh, that one.
My lord. The wife is in Tura, my lord. And wife. With item number 16 of the main list. Sorry.
Yes, tell me.
Lordship, yesterday they went to the office, and Lordship, we have also means we have tried our level best to do the needful, and they were insisting Lordship only for their freezing account. They are not promising even. We have asked them that okay, fine, whatever has happened now, from now onwards, you clear your backlog and also proceed with the current accounts, and you pay from next month onwards. You pay on time and clear your backlog also. But subsequently, they did not agreed on that, and they were insisting only for defreezing the account. Lordship, defreezing the account, the purpose is that means they have to clear. We could not come to any conclusion, Lordship, because we have given all the options, whatever the possible way, but it cannot be executed.
That is what I said, my lord, that they have, in fact, I was instructed that they have also received some detailed calculation of sorts for the relevant period. That is between 92 to 2008, my lord. So, to pay the current payment and all, that is a different thing, my lord. But we are concerned with 92 to 2008. That is the period. So, they have given some sort of, my lord, a detailed calculation along with the days and all that. So what the petitioners, they have taken that copy, my lord, and they are sitting and trying to verify it with their physical challans and all that. In the meanwhile, my lord, we prayed to the respondents, my lord, that let us operate the bank account, because admittedly it is not helping either side. It is not that they are getting any benefit by freezing the account. That is my submission. And the end of the day, my lord, what transpired is that they asked the petitioners to give a written assurance that they will pay the entire amount. That naturally cannot be done because they are still resolving the, my lord, dispute, if there is any dispute. So now if I give a written undertaking to them that I will pay the entire amount, then, my lord, the entire matter it becomes redundant. What they are doing, my lord, is that they are sitting with the cross verification, my lord, and in the meanwhile my prayer is to unfreeze the bank account, because admittedly it is not helping anyone, my lord. And at the end of the day, my lord, by giving the contribution, it is the employees of my school who will be benefited. It is not their employees who will be benefited or their officers. But on one hand, my lord, there is an allegation that I have made delayed payment. It is not the case of failure of payment. It is a case of delayed payment and interest on that delayed payment, which I have stated right from the very beginning, my lord, that if I am liable to pay, once the entire issue has resolved amicably, we will pay whatever is required to be paid, if any. And in the meanwhile, what is happening is that the bank account, which is used for n number of purposes for the daily activities of the school.
Anyway, Mr. Dev, do you give an undertaking before this court that you will pay whatever is due?
As per, my lord, I'm not saying that whatever they have stated is the
that is subject to
if there is any due,
subject to correction, cross correction, or calculation, whatever the case may be. What they would also require is for you to pay what is due and payable to them. Nothing more, nothing less. And of course, like you said, you have to cross check your your accounts and so on and so forth. So that exercise may take some time, of course.
Because if your lordship,
but the primary
grievance
is for you to pay.
Absolutely.
And if that assurance or undertaking is given, then the matter ends there.
No, in my humble submission, my lord, that if now they have already sat yesterday and they have had some communication. Now, eventually, if the parties agree that the amount that was originally claimed is in fact the correct amount, then that amount will be paid, my lord. I am liable to pay it as per the
Exactly.
law. If it comes that that is not the correct amount, and it may be more or less or whatever it is, then as per what is decided will be paid. Or if it is a case that I have paid, then I will not be liable to pay anymore.
Yes.
So in
Those things, you see, those let's put it this way: nitty-gritty has to be sorted out by
internally,
by the parties. Yeah.
And why we were aggrieved, Lordship, may kindly I will just show one point, my lord. Kindly have the writ petition at page 31, my lord.
Yes.
Page 31, my lord, this was the judgment of 27th January 2012 between the same parties, my lord. In essence, the same dispute arose, Lordship. That was for the period of 1996 to 1999, my lord. If I may read paragraph 2, my lord, very quickly.
Yes.
The case of the petitioner is that his school was arbitrarily brought within the purview of the Act in the year 2000, but with effect from 1983. He then informed the respondents that the school had only 20 employees from 96, and therefore contended that the school should have accordingly been asked to deposit the EPF dues only with effect from 1996 and not with effect from 1983, when the school did not have 20 employees or more. His representation to that effect was, however, not accepted by the respondent authorities, and the school was thus asked to deposit the EPF dues with effect from 1983. The school accordingly paid all dues as directed. However, to the contention of the petitioner's school, the respondents in their final order dated so-and-so levied interest and penal damages upon them with effect from February 1996 to March 1999 for the alleged delay in depositing the dues. What I understand from here, my lord, is that they initially said that we are supposed to pay from 82. We said that no, we did not have the number of employees required for being under the ambit of this act, so we will pay from 96. And there is a statement, my lord, which has been recorded in the order, that the school thereafter accordingly paid the dues. Because they rejected our condition, we paid the dues. The challenge before the court was between 96 to 99. So before 96, my lord, it is an admitted position that they have paid the dues. This 96 to 99, my lord, must set aside, and they were directed to pay 25%, which lordship will find the applicable law at page 33.
Yes.
Page 33, my lord, talks about the Apex Court judgment of Halwasia Vidya Bihar versus Regional Provident Fund Commissioner, which is in bold, my lord.
Yes.
And also the amended provision at 32A. Lordship will find the amended provision at D, my lord, right at the bottom of the page. If the period of default is 6 months or above, the rate of damages that can be recovered is 25%. So hence, my lord, for 96 to 99, which was then challenged, the position was that before 96, dues were paid. And 96 to 99, we were directed to pay 25%, which admittedly we have paid. Now, my lord, they again asked to pay from 1992, my lord, saying that that still stands. And whatever that may be, my lord, that those things have to, that is why I'm saying those things have to be, my lord, amicably settled.
You have to be sorted out.
And at the end of the day, the law is that we have to pay 25% of the damage. So whether the amount that they're claiming is 25% of the arrears, or whether it is the entire 100%, that also is an issue that has to be settled, my lord. So in the meanwhile, by freezing the bank account, what is happening is my current contributions are getting hampered. The daily activities of the school, salary, petty, my lord, expenditures entirely stalled, my lord, and they are not getting anything out of it. So I will only pray, my lord, let the bank account be operated. We will, lordship may grant us some time. We will try to settle it. If not, my lord, then of course it has to be decided otherwise.
Lordship,
And
here
in fact,
the
only one small. In fact, my lord, when we moved the matter, the recovery certificate was issued to us, my lord, had some patent errors with regard to the period. That is of course a different thing, my lord. But thereafter what they have done is they have issued a corrigendum. simply by changing the date. Amount remains the same, and they have sent it to us. It's not on record. I may be allowed to place it by affidavit. So essentially, now we're dealing with that final, the corrected malord.
That will come in course of
Yes.
the hearing.
I had to point it out because it is after the proceedings had been initiated. They issued the corrigendum. So whatever it is,
But those are all technicalities.
yes, my only submission is let the parties sit. They have had one meeting. If it can be resolved, that will be beneficial to all of us, my lord. And in the meantime, the bank account should be unfrozen because it does not help either party. And
Lordship, the proceedings is under 14B, Lordship. Now what 14B says, Lordship? 14B says that it is the penalty towards the damage, Lordship. Now, if they are supposed to pay on 15th, they have delayed the payment, so penalty is on the delay dates. Now, Lordship, which I have pointed initially also, this does not, they have not, in the writ petition, they have not enclosed the detail calculations, like for the month of January, how much they paid and what is the due date and when they have paid. Everything is there. Every required things we have already provided, which is they have not enclosed in the writ petition. Moreover, Lordship, they have not enclosed the rectified also. The rectified.
that has been passed after filing. That is what I was saying.
No, it is not passed after filing. It is passed before that only. It is 16/01/2023, Lordship. 2023. That is rectified.
Anyway, okay, that, like I said again,
We have already given them everything.
So
Now, what happened yesterday, Lordship? Yesterday we were trying to set, because from our end we are at the receiving end. So everything is like we will try our level best so that they pay, and for the betterment of the employee also, that if they pay us, we do not have anything. We are not their enemies or something. We are helping the employees. If you pay, we are ready to cooperate. Now yesterday what?
How are they helping the buy employees?
Just a moment, later.
Now when they are like when the calculations and everything we have already given them, it's way back in 14/2/2023. We have prior to that only the summons, Lordship. The summon is not here, Lordship. We have prior to that we have issued summon. After the summons, we have already given them.
The fact
So
remains,
now till that time they have
the
not.
fact remains you are yet to file your counter.
I am yet to file my reply.
So you do that and bring out all those facts.
Okay.
In the meantime, let the process of negotiation continue.
Okay.
You may have said yesterday, it may have it may not have been productive or successful, but you can continue. I believe the intention is clear as far as the petitioner is concerned, and you are also.
We are paying right
And
80 to
at the end of the day, as has been rightly submitted by Ms. Varshaji, is we have to look at the welfare of the employees.
Exactly, my lord. So my humble submission
You
is
cannot deprive them of their right.
Naturally, my lord. It, like she said, my lord, that what we are liable to pay according to them is the interest on the delayed payment. It is not that we have not made the.
And how is the interest disbursed?
Interest calculation is already there.
How is it disbursed? Does it goes to your account? It goes to the account of the employees.
It goes to the government exchequers. Because this is a penalty. So it is a penalty. So penalty is to be calculated with, like, we invest in the government exchequers, government funds, and thereafter whatever the interest we get, sometimes because we have to give it to the pension scheme also. There is now the scheme has come, higher pension scheme also. So we have to give interest on returns also. So all these are things we need. So
I am praying only for an observation, my lord, that we may be allowed to operate the bank.
Yeah, I think you can do that.
Lordship, there is no prayer to for that purpose.
Doesn't matter. Doesn't matter.
At prayer 4,
Once the matter is seasoned by the court, effective order can be passed.
Lordship, let them because if now the account is defreezed, Lordship, The problem will be that they will not agree to pay, Lordship. That is the
No, miss.
they,
See,
they are
as I see, time and again, the court has sought a commitment from the petitioner. In principle, they have agreed. They have agreed to comply with whatever is demanded of them. As far as what is left is only the calculation part. So, to that extent, the court will take the submission of the counsel on record. If, God forbid, they choose to ignore that direction, then necessary proceedings will follow. Simple as that. You need not be, you need not be, worried about that. But you also have to understand the situation. If they are not allowed to operate the account, how will they,
Nothing can be done.
operate it? How will they disburse the fund to you, money to you from that account? If it is freeze, you are not allowed to operate it. Neither are they.
It is just lying.
It's just lying.
And it's not helping anyone.
But in the meantime, you fix another date. Do it as fast as possible.
Yes.
Within the course of a week.
In fact, yesterday I was instructed that they had asked for a week's time or so, that by the end of the week, because yesterday they were given some calculations, so they have asked for some time, and it was not the case that the entire thing was concluded.
Heard legal counsel for the petitioner, also heard legal counsel for the respondents. Can you get a meet case? The legal counsel for the respondent has submitted that the counter affidavit may be allowed to be filed. How long? 2 weeks.
3 weeks, Lordship.
Within 3 weeks. Pray aloud. Now, Vichaka, miss case, no? Heard legal counsel for the parties. Mr. Deb, the legal counsel for the petitioner, has submitted that the parties have met and discussed the matter in dispute. Have met on
Yesterday, 27th.
27th, 6, to discuss about the matter in dispute. However, nothing concrete has emerged. It is therefore submitted that some more time may be allowed for the parties to continue with the settlement process and to come back to this court with specific report in this regard. It is also the prayer of the legal counsel that, given the assurance of the petitioner that it will not default or avoid payment of whatever is due and payable as far as the contribution from its part is concerned. However, the fact that the relevant bank account is still, should we use the word frozen?
Seized or not?
Doesn't sound like it's ice.
Local language is frozen. I don't know what is the banking term for it.
I know what we can assist. Yeah, what is the banking term?
banking term, actually it is the
Suspended.
word is freezed is used for banking term, but then now the bank, because it is neither in an operational state, we cannot say that it is freezed because no order is passed with regard to freezed, but we can say that it is not in an operational stage.
Let's put it that way. Name to no. Is however the operation. However, the fact that the operation of the said bank account is suspended
And no transaction can be made.
and no transaction could be made from the said account, the difficulty would lie in as much as the petitioner are required to operate the said account for its day-to-day requirement, and also if any disbursement of funds to the respondent organization is to be made, the money would come out of the said account. To this extent, it is prayed that the said account will be directed to be I think there's a word I forgot. Directed to be allowed to directed to be allowed to operate, to be operated by the petitioner. Thanks. Though certain reservation has been expressed by the learned counsel for the respondent in this regard, it is however obvious that the operation of the said account would play a major part in the settlement of the dispute between the parties. Accordingly, by the way, what about the bank? You have not.
They have not taken any steps towards the bank.
Have you taken steps for
On
issue?
the last occasion, we have taken steps, my lord, but service affidavit is yet to be filed.
What is the name of the bank?
State Bank, my lord.
State Bank, which branch?
Rinja branch. Lordship, yes. State Bank, Rinja, State Bank of India.
The last line.
It is, however, obvious that the operation of the said account would play a major role, part in a major part in the settlement of the dispute between the parties.
Accordingly, the account of the petitioner's school you have only one account there? In the State Bank of India, Ranjat branch, Shillong, is hereby directed to be released from any encumbrance to allow the petitioner school to operate it. It is, however, made clear that in the event the conduct of the petitioner in these proceedings is found wanting, it is open to the respondent to make a prayer for freezing of the said account in due course. This petition, this case, accordingly disposed of. I have not stated that you will meet. So should we?
Lordship, let it come after 1 week. My affidavit is on. I'm praying for 3 weeks, but let it come after 1 week again. In the meantime, let them come and meet with whatever we have provided the thing. They check.
Should we pass that in the miss case or the main case?
In the main case, my lord. In the meanwhile, by the time they file their affidavit, another meeting may be held.
Because let it come within 1 week, Lordship. Otherwise,
main case mo to. Katuga ano kuni I paragraph. No service report has been received as far as the notice
Respondent 4.
issued upon the respondent 4 is concerned. Learned counsel for the petitioner has submitted that the report may be awaited. The same may be awaited. As far as the next meeting is concerned, the parties have agreed to meet on. Can you give a date or you need instructions?
I need instructions for the specific date, my lord. Maybe in this week itself, my lord. Lordship, within this week.
Yeah, day after tomorrow.
Lordship, let it be on day after tomorrow. Then third, fourth, let it.
But can you?
Tomorrow is a holiday, my lord.
Tomorrow is a holiday.
Tomorrow is holiday.
Let it be by 7th of July.
Because
my lord. That would be
what happened is, you see, you still have to get confirmation from both sides as to whether they are free on the. Okay, we'll give it within a week from today. Within a week from today. So week from today means the next Thursday. Within next Thursday.
Okay.
Kunum tomorrow? Within a week from today. The date to be mutually decided by both parties.
Okay.
Okay, so we'll leave the other part aside. Next time the case is listed after 3 weeks, by then the report of the meeting may have been furnished.
Because, my lord, what happens is if we dispute the amount, then this may not be the proper forum to adjudicate that dispute.
Perhaps. It becomes a question of facts. So
Facts. It has to go to appeal.
that will have to go before.
The outcome of the negotiation is very important.
Fine.
Thank you.
Hello.